Let's start. Good afternoon. My name is Karl Kasparovich, and for my presentation as part of portfolio, I chose the sphere of European Union legislation. Therefore, today I'll talk about the direct effect, the types of it, and I mentioned the direct effect of directives in particular. Then I'll go through the problems in this sphere, and I'll propose the solutions of these problems. Therefore, I think the better way to start is to give a definition of direct effect. Direct effect means that the source of law creates individual rights and national courts must protect them. Firstly, it was mentioned in the case of Langen and Lewis, where the court stated that Treaty of European Union articles, they may be granted direct effect in case if they are clear, unconditional, and there is no need for further implementation. This term, this definition, shall not be confused with direct applicability. Direct applicability is a principle that is stated on Treaty on the Function of the European Union. It relates to regulations as sources of law. It actually says that there is no need for further implementation of regulation because it takes effect as soon as it was published. Now it's better to mention the two types of the direct effect. The first one is vertical direct effect. It actually means that the person can enforce his own rights against states. This type of direct effect was mentioned in case Langen and Lewis. In case Dufresne and Sabina, another type was stated, horizontal direct effect. It actually means that the person can enforce his own rights against another person. As I already said, the direct effect was widened by European Court of Justice. So the approach of the court depends on the sources of law. Let's move to directives. Directives, the most ambiguous issues related to directives because of their nature. Directive as a source of law should be implemented by member states in the national legislation system. Therefore, member state has a choice of form, method, and it has a particular period of time for implementation. Logically, it means that there should not be any direct effect at all because it doesn't satisfy the criteria set in Langen and Lewis. I mean, no need for further implementation. But the European Court of Justice had another point of view. In the case of Berlin Home Office, it said that the directive can have a direct effect if the wording is sufficiently precise and the implementation period for the directive had passed. Next, the type of direct effect should be mentioned because it's crucial in this situation. Vertical direct effect was granted in the case of Marshall, and there's actually no problem with that. But the turning point was the case between Werner Mandelt and Rüdiger Hahn. In this situation, the directive could not be applied because the implementation period of it hadn't passed. But the European Court of Justice decided that the directive contains such provisions that are actually part of general principle of European Union law of non-discrimination based on the age. Therefore, the directive was granted horizontal direct effect in this case, despite the fact that implementation period hadn't passed. This case was meant to be exception because actually the more simple logic in this situation would be to say that general principle was directly applied, not direct. But this position in particular was supported in the case of Kudevich. Therefore, it was highly criticized. The main critique is the following, I quote. The court, of its own volition, without good reason and against the wishes of legislation, extended the scope of the directive by giving to it direct effect before implementation period expired by reference to a general principle of European Union law. General principle is the main problem here because there is no static list of general principles exist. Therefore, some principles may be added to it, some principles may fall out of it. Moreover, general principles are abstract. In other words, the principles are not the concrete norms that regulate certain relationships, but it's better to say that they show the particular direction to member states, how they should develop their legislation. This actually means that even if we identify the particular list of general principles, the question about their content arises. In Mankelton-Heron case, the principle of non-discrimination on the ground of age was used, it was protected. But what about other grounds, for example, religion, political views, membership of national minorities, gender, etc.? The question is, will the courts protect these grounds in the same way, or will it take another approach? The court doesn't answer these questions, and it leads us to the main problem, legal uncertainty. In this situation that exists right now, people cannot actually trust the national legislation because they should take into account general principles of European Union law. As Peter Dybvig mentions in his article, directives are quite widely used in the European Union. Therefore, wide and unpredictable interpretation of this source of law undermines the trust of people in national legislation because they cannot be sure in the outcome of their disputes. The problem of legal uncertainty can be solved in particular ways. The most popular decision, the most popular proposition maybe, is to abolish the horizontal direct effect of directives at all, because it blurs the distinction between directive and regulation as a source of law. This point was made in the case of Facinidori. Other people say that, okay, we agree with that, but after the implementation period had passed, we do not see the ground for this decision because after the implementation period, directive and regulations become close to each other in their consequences. Therefore, we do not see the ground for protecting the rights granted by these two sources of law in different ways. I believe that the most reasonable solution was proposed by Advocate General Colomer in his case Otmar Mikhaeli. In this case, he said that we can have two situations. First of all, we can have a directive that regulates particular relationships. In this situation, we can use general principle of European Union law, but only for interpretation of directive's provisions. Therefore, directive is the source of law that we will apply to the particular case. In the next situation, there is no directive, and therefore we have no problem at all because general principle can be directly applied to the particular relationships. It should be mentioned that Advocate General Colomer was actually against the horizontal direct effect of at all. But I want to concentrate on this particular idea because, firstly, it respects the hierarchy of European Union norms, and secondly, it provides people with legal certainty because in this situation, the individual will be sure that this particular source of law will be used in this without the person time, and this source of law will not be used. Therefore, the predictability of outcome of the dispute will be high. And therefore, I think that the European Court of Justice should follow this approach in particular and make it official in the next case. Moreover, I would like to mention that people really need the legal certainty. They need to be certain in the outcome of their dispute because it's costly and they need particular time for it, and they should be sure how to protect their rights. Moreover, legal certainty is also a general principle of European Union law. Therefore, the European Court of Justice should not forget that it should protect and it should effectively guarantee this principle in the role with other principles. So, thank you for your attention. If you have any questions, please ask them. I'm ready to answer them.
Can you give me, would it be possible for you to give me an example of Colomer's solutions? Can you give me an example of a concrete case where it might apply?
It's actually hard to get a concrete case because they cannot have a situation where there's at the same time directive and there is no directive. So these two situations actually exclude each other. What he means is that, for example, in a particular situation when migration of workers, right, is regulated. If there is a particular directive in this situation for migration of workers, then we should apply this directive. It's the primary source of law that we should use. But if there is no directive in this situation, then we can use the general principles of European Union law as a more general way, right? It's more abstract, and we can understand the logic of it and use it in a particular case. This is the main idea of this proposition.
Would that situation, second situation, when you're using general principles, do you think that would aid or hinder certainty? Because you've emphasised the importance of certainty.
It's actually, thank you for your question, it's a really interesting question. I think, of course, it's will be hard enough because, as I already mentioned, the general principles are abstract. And therefore, this is, I believe, another problem. So I'll try to figure out the hierarchy of European union norms. But the situation of general principles, of course, it should be also considered, and maybe the particular list should be used. And of course, the situation where there's no directive and you should use the general principles, it's not right. It means that you have a particular gap in your regulation of particular relationships, so you should avoid it. But if you do not have another situation, you have another source of law, then something should be used, and the general principle seems to be the particular source of the situation.
Thank you.
Do you think that in following this approach, that they're moving towards a more common law system of reasoning, or it seems a very I was going to say uncivil, but I don't mean quite that. It means not a particularly strong approach from a civil law jurisdiction to move in this kind of way. It sounds much more like the common law, doesn't it, in the sense that you have a regulation, a directive, which is effectively a law, a statute. And if you don't have one, then you fill the gap with the common law. But of course here instead we have a general principle. Or do you think that it's more akin to another legal system?
Yes, I agree with you. That it seems to be closer to the common law system. But we shouldn't forget that the decisions of European Court of Justice, they actually have a particular influence on the relationships. It means that it is already some parts of common law exist. And moreover, it's globalization, and we can have parts of different systems as civil law and common law. I believe that we should integrate them in one and make a benefit from it. So I think that there is no problem in the situation, but you're right, yeah, it's close to the common law system.
Does anyone else want to ask a question? Very wide, it's always kind. All right, thank you very much.
Thank you.
Sure, go ahead.
Good afternoon, ladies and gentlemen, colleagues. My name is Ruslan Rulev, and I will be giving a portfolio presentation. The topic of my presentation is idea expression distinction in English copyright law. My presentation will be broken down into three parts. I will first explain how the idea expression distinction works in practice. What are its functions? In the second part, I will discuss some difficult cases, which may be criticized. And finally, we will see whether there is a room for reform in this field. The purpose of copyright law is protection of skill, labor, and judgment, which is involved in creation of original works. This protection is afforded through giving exclusive rights to use these works for a certain period of time. But the ideas themselves are not protected by these exclusive rights. Only expressions may be protected. The difference between the ideas and expressions are that ideas, as we can see, exist in our heads, but they can be projected outside in the form of expressions. For example, quite a simple and general idea of little green man existing on another planet may be projected outside in the form of a scientific research as a science fiction novel or in a film, for example, Star Wars. All these expressions will be covered by copyright, but the general idea behind them, the idea of Little Green Man, will not be protected. Idea expression distinction also serves another function. It allows to ascertain the scope of protection. For example, the film Star Wars will not infringe the copyright in scientific research, although both of them are based on a similar idea. One work can only infringe the copyright in another if a substantial part of the first work is taken. The operation of idea expression distinction can be easily demonstrated in the following circumstances. I'm sure that some of us have watched the recent action film called Cowboys and Aliens, but few people know that in 1995 Steven Boosty created a comic based on a similar topic. And recently, nearly a couple of months ago, he sued the directors of the film for breach of copyright for using the same idea. Now, I would like to emphasize the following point. There are established genres of the films. Western films, which are usually about cowboys, and science fiction films, which are sometimes are about aliens. But if we take these two different ideas together, the result may be specific and precise enough to constitute an expression. Thus, Steven Boosty may have a chance in court. I would like now to move to the second part and discuss some of the difficult cases of application of idea expression distinction. The first case is Elanco and Mendoza. In this case, the copyright protection was sought for instructions for the herbicide. The claimant sued the defendant, and the defendant tried twice to rewrite the instructions so as to escape the liability. But this did not help his case. The court decided in favor of the claimant. Now, I would like you to think, could you propose any other way of writing instructions for herbicide? Probably not. Edward Samuels maintains that in such instances, ideas are merged with expressions, and thus only one expression of a certain idea is possible. This is why it may be unjust to give copyright for instructions, because it would be entirely impossible to write them in any other way. The second case is Creation Records and News Group newspapers. In this case, the claimant asked for copyright protection of a particular setup which was created for a photo shoot of the new album cover for Oasis Group. In this case, the claimant invested significant creative and financial resources into creation of this setup. They booked the whole swimming pool, sent a Rolls-Royce car, arranged particular items to create a certain expression. After the consideration of the facts of the case, the court decided that the setup should not be given copyright protection because it's an idea, not an expression. The reason behind this decision is that this setup does not fall into one of the categories of the recognized forms of expression. It cannot be a sculpture because there is not enough, because a certain degree of permanence is lacking. It cannot be a dramatic performance because there are actually no performance. The people are just standing in a photo shoot. Now, it may be that the court is unduly conservative in its views in declining to recognize new forms of expression. Based on the criticism of these two cases, Patrick Messier-Pourima, in his recent article, proposes to adopt a new and purposive approach to the idea expression distinction. In other words, in each case where the court is concerned with the expression distinction, it should also always ask the question, how can we protect creative skill, labor, and judgment in the present case? Now, if we adopt this approach, the cases like Elanco and Mendoza and Creation Records could have been decided differently. For example, in Elanco and Mendoza, the case about the herbicide and instructions. What was in fact protected is not actually creative efforts which were used in creation of the instructions. but rather the industrial investment into the production and marketing of the end product, of the herbicide. And this should be left for patent law and not for copyright law. Croatian Records case could have also been decided differently. In that case, creative skill, labor, and judgment was not protected at all, for reasons perhaps of formalism. Before making a conclusion, I would like to once again emphasize that as a concept, the idea expression distinction serves very important and necessary purposes, but its implementation is not without its shortcomings. There are some cases which perhaps were decided wrongly. With this, I would like to finish my presentation and thank you for your attention. If you have any questions, I would be more than happy to answer them. Thank you.
Thank you. Just one question. The Busti case, how would the, I'm sorry, I'm not going to pronounce it properly, Nasia Karima approach impact on this case, do you think? I take it there's been no decision in this case.
Yeah, there is no decision there.
Okay, so what do you think the decision
like this case? Yeah. That's actually a very good question. I think, firstly, it would be difficult to establish the causal connection between the comic, which was produced and published in 1995, and the new film. Because more than 10 years has passed, and it will be difficult to prove that the directors of the film used this material. So this is the first point. And the second point, about actually the purpose of protection, creative skill, labor, and judgment, I think it will depend on the fact whether the directors of a film tried to free ride on the previous ideas which was used by Steven Busti while he was creating his comic. I hope this answers your question.
Okay, thank you.
In terms of, look at the case myself, where you talked about ideas emerge with an expression, this one here, the idea here is that there's only one way that the thing can come out, as it were. The instructions can only be written in particular ways. How often does that crop up in this case? I mean, is this a typical case, or is this, is this one of many cases in this area?
Well, let's think how often we need to protect the manuals, the instructions. Possibly there are numerous instances of this, and I think it may come out quite often. And this is why the court should be very careful in deciding this case.
Because I mean, you think of many everyday things, a cleaning product of any kind. You simply spray it and wipe it off. And it's difficult to think how you can tell anyone to do that. You can change the words, but you're not going to change the sense of it in any
that's the whole point of the case.
Then you're not just going to be able to get anywhere. The difficulty, what about then turning to your final one of the Rolls Royce in the swimming pool?
Yeah.
Which I suppose anyone could create by Photoshop these days without any need to rent a swimming pool. Even I could run that up. What I was kind of wondering here is, I can see that this guy, Nasia Karima, is looking to kind of come up with a more creative idea. But it's almost like the creations are so... this is, in truth, I wasn't really joking, this is the kind of thing a teenager could come up with at home now, isn't it? And many people can create this kind of thing. Does that not really mean it that actually this area of law has to kind of almost step back, because it's almost a way in which trying to copyright these or protect these things is actually impossible? Or do you think that I'm the Philistine?
I see your point. Obviously this case was decided before 2000, and we should understand that the protection of a picture or a photograph or a computer-generated image is quite simple. But in this case, what they tried to protect was not a photograph, because it would not have brought him any good.
Right.
They tried to protect the whole setup.
Right.
And as far as such setups are popular nowadays, well, what if we think of setup of a certain piece of art? If we talk about an exhibition.
Yes.
This is also a setup, and I think that it should be protected. And the instance of Photoshop is not really relevant here, I think.
But would that not go back to, I take your point, I suppose it would depend how complicated it was.
Yeah.
But if we just pursue that for a moment, if you said that setting up a particular art show was subject to copyright,
Yeah.
if you look at, let us say, there is one piece which is 2 meters high and 2 meters square, there is another piece that is 1 meter high and 1 meter square, right? And another which is half a meter high, right? How many ways can you set that up? Do you see what I'm getting at? How, kind of up me back to the instruction manual, because if you have a certain numbers of piece of art, and you say to them, you can't set it up as I set it up, because if you do, you're breaching my copyright. The person is going to be limited to just moving them, say, okay, I'll set it up in the same way, but move it to the left-hand corner rather than the right-hand corner. Do you see the...
Yeah, I see your point, yeah. Well, there are two arguments. The first argument, which concerns directly the expression distinction, is that a thing, a work must be specific enough to be considered an expression. If you just have an idea of placing an object which is 1 meter and another object, this will still be considered an idea, not expression.
Okay.
This is the first point.
Right.
And the second point is that if this development of this setup is really mundane, it will not be original in corporate sense, and thus will not be protected under this ground.
Okay. Thank you very much.
Mind you, you'd be surprised how mundane some modern art is. Thank you. Thank you very much.
Good afternoon, ladies and gentlemen. My name is Alexei Pashinsky, and today I will present you a topic from the elements of the law of contract, which is called classification of contractual terms. The problematic issues of my presentation are certainty and flexibility of this classification. As we know, a contract contains certain terms, and some terms are more important than others, as remarked by Professor Evan McKendrick in his book, Handbook on Contract Law. It is critical for the parties to establish correct classification of contractual terms in case they are breached. Why? Because if the term is breached, there are different consequences if a certain type of term is breached. Basically, there are two classifications. The first classification focuses on the nature of terms, and it draws distinction between conditions and warranties. A condition is the most important term in a contract. It goes to the root of the contract. So if I breach a condition, you are entitled to terminate the contract, which is a very drastic remedy, and you are also entitled to claim damages. However, there is also a warranty. A warranty is not so important as condition. It does not go to the root of contract. And if I breach a warranty, you are entitled, you as an innocent party, you are entitled only to claim damages. The second approach focuses on seriousness of breach. It doesn't matter whether a term is a condition or a warranty. Now, both these classifications represent the issues of certainty and flexibility and shall be dealt in turn. The first one is conditions and warranties. How do we tell what is a condition and what is a warranty? Well, traditionally, the difference between them has been demonstrated by comparing two cases with similar facts. The first one is Ussed and Spears, where an actress's obligation to perform at an opening night of a theatrical production has been regarded as a condition, while in Bettini and Guy, an opera singer failed to attend half of rehearsals, but this did not go to the root of contract, and therefore the court held that this was a warranty. Now, how else could we tell what is a condition and what's a warranty? Well, there is a statutory classification introduced by Sale of Goods Act 1979. where implied terms as to title, description of goods, fitness, quality, sample are regarded as conditions. However, there is an exception for non-consumers, for buyers as non-consumers, for business people. And if this breach is so slight that it would be unreasonable to reject goods. And this applies to description, fitness, quality, and sample. Now, these terms would be regarded as warranties. There is also a judicial classification, where the judges look at the party's intention, like in Couchman and Hill, where the judges looked at the intention of the buyer of a cow, where he intended that a cow must be healthy and a cow must not bear a calf in it. And the second is the judges look for any binding authority, like some significant commercial significance of certain terms. Like, for example, time stipulation term in a voyage charter party, which are usually held as conditions. This was the case in Michalis Angelos. Also, the parties themselves can expressly classify or label a particular term as a condition. But one should remember that not all judges are convinced by such classification. Like in Schuller and Wickman, where the parties drafted in a contract that it is a condition that one party shall visit clients at least one time a week. Well, the court said that you use this term as condition in its technical sense. And even though you labeled this as a condition, classifying a term as a condition is not of particular significance. And therefore we held that, therefore the court held that this was a warranty. However, Lord Wilberforce dissented from this opinion. He said that their lordships confused that the parties intended to use the flexible approach rather than the strict approach. Or maybe this was a result of bad draft or poor drafting. Maybe they had bad lawyers. However, they did not have bad lawyers in Lombard North and Butterworth, where an obligation to pay each installment promptly was held to be a condition. Well, moving on. As we can see, the obvious advantage of classifying terms as conditions or warranties is certainty. If I know what term is breached, which type of term is breached, I know how to react. However, the need for certainty must be weighed against the need to reach a fair decision in individual cases. Like, for example, substantial breach of warranty. The innocent party suffers great damage, however, it still cannot terminate the contract. Or, if there is an insubstantial breach of condition, the innocent party suffers little damage or absolutely no damage, it still can terminate the contract and claim damages, which was the case in Arcos and Ronassen, where 9/16 inch thick timber was delivered instead of 1/2 inch thick timber, which was made to produce barrels. And the innocent party said that you broke the condition and therefore I terminate the agreement and claim damages from you. Well, the real reason why the innocent party did that is that it wanted to escape a bad bargain, and which seems to be unfair. And in order to deal with this unfairness, a new flexible approach has been introduced, which bases the right of termination on the seriousness of breach. And this is the concept of innominate terms. The judges will wait and see whether the consequences of the breach will deprive the innocent party from the whole benefit. If it does deprive them, then the innocent party will be entitled to damages and will be entitled to terminate the agreement. If it does not, then you will be only entitled to damages only. This was introduced in the case of Hong Kong Fair Shipping Company in 1962, where there was a 2 years charter party contract, and there was a term that a vessel shall be in every way fitted for ordinary cargo services. However, due to repairs, the vessel stayed in the port for 4 months, but it still had 20 months of performance. And the charterer said that you breached a condition and therefore I terminate the agreement. However, the court said that seaworthiness was not a condition, it is merely a warrant, it is merely an innominate term. And you still had you still had 20 months of performance of contract, so you were not substantially deprived from the benefit of the whole contract. Another example is the case of Hans Nord, where this was a case about delivering citrus pulp pellets, which is cattle food actually. This is the cattle food actually. Yes, and there was a term. Yes, there was a term that a shipment must be made in a good condition. However, after the delivery, it was discovered that some of the citrus pulp pellets were not in good condition, and therefore the innocent party said that you breached the condition, and therefore I reject the entire cargo, and I terminate the agreement and claim the damages. However, the court said that this is not a condition. This is an innominate term, and the real reason why you want to terminate the contract is, again, you want to escape a bad bargain in order to take advantage of the drop of the market price. Therefore, we see how innominate terms deal with such bad bargain escape issues. So, innominate terms do bring some remedial flexibility. However, at which cost? At what cost? At the cost of certainty. Because, therefore, business people want to know how to react quickly if the term is breached. But using the wait-and-see approach, they cannot. It is impossible for them to terminate with certainty. Maybe they will be sued for wrongful termination. So, and the judges acknowledge this, and now using wait-and-see approach would cause unfairness. For example, in mercantile contracts, like again in Michalis Angelos and Bunch Corporation and Tradex, where in such mercantile contracts, time stipulation clauses are of high importance, are of essence for the contract. Time is money in these contracts. And therefore, we can see that from 1962, the courts introduced a balanced approach. And nowadays, as Lord Wilberforce suggested, the courts should not be too ready to interpret contractual clauses as conditions. And this brings me to a conclusion that nowadays exists a balanced approach used by the courts. Apart from commercially vital terms, where certainty is greatest, greater importance shall be dealt with the interests of justice, and therefore the courts shall be given flexibility in granting an appropriate relief. This is the end of my presentation. Thank you for your attention, and I'm ready to answer your questions.
Does this suggest a tension, do you think, between the inherent principle that underpins contract law, that the parties are free to make whatever the bargain they like?
Yes, absolutely.
Do you think there was a tension there? And which?
Thank you for the question. Yes, as we know, there is a freedom of contract. The parties are free to label any term as a condition because it is for them important. I want this shirt to be red or black, but it is a shirt. For example, if one brings me a shirt, but it is not of color that I needed, I want to terminate the agreement because this is what freedom of contract is all about. There were tensions because of the unfair motives of terminating agreement, and as I said, sometimes the so-called innocent parties wanted to simply escape a bad bargain because there was a market drop in the prices, and they escaped on a technicality. They terminated the agreement on a technicality, and they made a new bargain, which is more profitable for them. So therefore, there was tension, and there was unfairness. However, as I suppose, the courts now have found a balanced approach.
I take it this approach applies not just when they label their terms, but it also applies if they make a very specific request.
Yes. As I said, if they have a bad lawyer which poorly drafts a contract term, it is, and if the case goes to the court, it is impossible to decide how judges will they hold that it is a condition or a warranty or an innominate term. It creates uncertainty. Therefore, the lawyers should draft all these terms in the best way they could.
This balanced approach, is it really a very certain approach, or is it in itself subject to interpretation?
Certainly. I think it is subject to interpretation. Thank you for the question, but I just put two parts of this to classification and made a conclusion that nowadays the courts should first look at the parties' intention, whether they really intended it, because freedom of contract is important. However, they should also see some other motives, and therefore this is the balanced approach. Yes, I understand your concern, because using innominate terms approach itself needs interpretation. There are lots of factors which need to be considered by the judges, and nowadays even the judges, they don't know which factors to judge. And
so my final question is, what would be your solution, your ideal solution?
Well, contract with good lawyers.
I think most of what I would ask was covered really, in the sense that it seems to me, one thing that I thought of when I was listening to it is that, in a way, if the judges would just keep out of it, they're only companies, they should just do it properly. They should say, make it clear, these are the key terms that are very important to us, and these are the ones that are less important to us. And know that if they break one, the contract will be over, and if they break the other, it might not be. And that would be fairly simple, because it's difficult to see, because the other one, particularly the cattle food one, you could just say any person with common sense would know that if a little bit was damaged and the majority it wasn't, the court is going to say, give them money or give them some more cattle feed. It seems terribly straightforward. It seems that either can work, but the problem, I think, with the balanced approach is that it might be better to push it back to the commercial world and make them bear the brunt of the contract.
I see your point, and it is nowadays that first commercial counterparties, they first go to the arbitrators, for example, or tribunals, where professional arbitrators who know all these technicalities, they know the significance of commercial terms. And then, if, for example, in London Chamber of International Arbitration, a dispute is resolved, and then it comes back to it comes all the way up to the court, the judges will, of course, look at the award which was issued in the tribunal and say, well, they were right. Actually, I don't have to do anything here. They were right. So that's my answer.
Okay, thank you.
Thank you.
Don't rush. Take your time.
Good afternoon, dear colleagues. My name is Dana Saventa, and today I'll be giving a presentation on one of the topics from the elements of the contract law, namely intention to create legal relations with respect to commercial arrangements. My presentation will consist of four main parts. Firstly, I'll examine the definition and nature of the intention to create legal relation. Then I'll move on to consider a rebuttable presumption which exists in relation to commercial arrangements. Then I'll examine the typical mechanisms used in commercial contracts to exclude intention. And we'll conclude with a question and answer session. As to the definition, intention to create legal relations is one of the vital parts for the formation of contract, together with offer, acceptance, consideration, and certainty of terms. The definition is largely unified. The classic statement was in the case of Balfour and Balfour, where it was defined as an intention by either party that the agreement be attended by legal consequences. It may be expanded, as it was done by Macmillan and Stone, that the agreement is binding with recourse to some external adjudicator or arbitrator in order to enforce the agreement. However, with the intention there are some problems, because intention is largely characterized by subjective and inner feelings of the person. And that's why the court is placed in a position when it needs to elucidate this intention. To do this, several theories were developed. The first one is subjective or pure theory. It presupposes that the intention can be literally carved out of the person's mind. Of course, this is not possible, at least to the full extent, and that's why the theory does not gain a lot of support nowadays. Then the second theory is objective one, or pure modified theory, and it is used nowadays primarily. It uses various judicial techniques or fictions in order to ascertain the intention. It may use objectively authenticated technique. That's whether a reasonable fly on the wall, judging by all the circumstances of the case, would consider that the parties did have an intention to create legal relation. Or they may use a reasonable man test. That's whether a reasonable man or businessman placed in the position the parties are placed would have an intention to create legal relation. And the most common thing is to use judicial presumptions. Presumptions which exist with respect to domestic and social arrangements and with respect to commercial arrangements. And before I embark on this, I need to comment on a third theory which is supported by only few academics, among whom we can mention Stephen Hadley. That is, there is no subjective intention and there is no objective intention, because what we have at the end is the intention of the judges who interpret this intention and make a decision judging by whether it will be fair and just to enforce the transaction. As I said, the most common technique is to use the presumptions. Two presumptions exist with respect to domestic and social arrangements and with respect to commercial arrangements. With respect to domestic and social arrangements, the presumption is that the parties do not have intention to create legal relations, and with respect to commercial arrangements, there is such a presumption. However, with respect to commercial arrangements, the threshold to rebut the presumption is really set very high. And in the following classic cases, like Esso Petroleum and Evans and Lawson, the presumption was not rebutted, and thus the contract was formed. In Esso Petroleum, Esso gave 3 World Cup coins for every 4 gallons of petrol to motorists. And the commissioners of customs would like to claim a purchase tax from this transaction, and in order to do so, they need to prove that there was an intention to create legal relations. However, the House of Lords was divided on the matter, but the majority took a presumption-based approach and said that it would be undesirable to allow a commercial promoter to claim that it did not have intention to create legal relations. And thus, the factors of triviality of transaction or the unwillingness of the parties to sue were not taken into account on the matter. In Evans and Lawson, the court took a slightly different approach, so it departed from a purely presumption-based approach and took a contextual approach. And in that case, the parties to the educational agreement were held to have a relevant intention to create legal relations. However, as I said, the presumption may be rebutted, and this was done in the following cases: Rosa and Frank Company and Kleiner Benson. The common feature of these two cases is though the parties expressly excluded their intention. And that's when I embark on the third issue of my presentation. These are the typical mechanisms used to exclude intention in commercial contracts. The typical mechanisms are comfort letters, honor clauses, and subject to contract clauses. As to the comfort letters are mainly used in loan finance transactions and are mainly associated with a group of companies. That's where a parent company issues a letter of comfort to a third party to provide some encouragement to proceed with the transaction. That's exactly what happened in the Kleiner Benson case. However, the court should not only look to the title of the letter, but to the wording and to the construction. And in that case, it was a statement of present facts and not a contractual promise as to the future conduct. And it was not intended to be anything other than a representation that a fact existed at the moment, giving a moral responsibility on the party of the defendants. As I said, we must look at the wording and at the construction. A pure comfort letter heading will not suffice in this case. As to the honor clauses, the classic case is Rosa and Frank Company. And honor clauses expressly exclude the courts as adjudicators, and state that agreement is binding in honor only. This is what happened in Rose and Frank Company. And the House of Lords held, in that case there was a framework agreement where a honor clause was inserted, and it applied to a right to terminate this framework agreement. However, under this framework agreement, particular agreements were initiated, and the House of Lords, wishing to hold the parties to their obligations, this kind of policy argument, said that where one party has fulfilled some obligation, the other party should have done so. And so, although the termination was lawful and the honor clause was valid, the party should compensate the other for the fulfilled obligation. And that was a kind of policy agreement. As to the subject to contract clauses, it's usually taken to mean that the parties have not yet reached an agreement and are in the process of negotiation. This is a very useful clause, and it usually helps to rebut the presumption because it's expressly stated that the parties exclude their intention. However, now the courts adopt more restrictive approach, and that's with the following cases. In the following cases, RTS flexible systems and intercom storage, the presumption was not rebutted. In RTS flexible systems, the Supreme Court held that, notwithstanding the fact that the parties did not have any formal contract, they had a draft contract, unsigned draft contract, but they proceeded with the transaction. They actually had agreed all the essential terms, and their course of conduct overrode the fact that they did not have any formal agreement. And in intercom storage case, the situation was slightly different. Because the parties did not insert exit subject to contract clause. They said that a formal contract is to follow in the process of their email negotiations. And the court held that a valid contract has been formed on the basis of email exchanges, because a formal contract to follow clause should be interpreted as a contract is only a formality and a contract may be formed during email negotiations. And then I'll be happy to answer your questions if you have some.
I suppose the obvious big question here is, do you think the position is satisfactory? It would appear from what you've summarised so far in commercial contracts that behaviour trumps words, in effect, that the parties will find themselves bound to a contract even though they might have used an honour clause or whatever because of subsequent behaviour. Would that be fair?
Yeah, I think that in case to subject to contract clause, it would be fair because the main function this clause stipulates is that the parties still need to negotiate some questions, and if they've done so, then they should write a formal contract and not act on the basis of subject to contract clause. And so the function of subject to contract clause is to proceed with negotiation. And in that case, Supreme Court, I think, rightly held that whenever they reach these sufficient terms, then the contract should be formed.
Okay. And the same even with honour clauses, comfort letters as well. That if you like, behaviour of other parties on the basis of the comfort letter will be enough, in a sense, to create a binding contract or binding obligation rather. So behaviour trumps again express words. Would that be a fair?
Well, there was no decision on the matter of comfort letters in relation to the conduct. But I think that the comfort letters, their main function is to provide encouragement. There are no guarantees. So if the party would like to obtain a legal guarantee, then it should go there. And the letter of comfort is just states the factual position on the time the letter is sent. And so that was stated in Klein Ben's case.
But it was quite specific again, wasn't it? It said that all that comfort letter was a statement of fact at that particular time. So you could possibly envisage comfort letters that aren't quite as carefully drafted.
Yeah.
Do you think that the position is satisfactory? Do you think it creates clarity around the law for commercial parties?
I think that if a commercial party really would like to exclude intention to create legal relations, it can do so if carefully draft these clauses and carefully use these mechanisms.
Okay, thank you.
I have a question. I can't think of it.
Thank you very much. Thank you.